In local news reports that Mr. Thompson showed you concerning claims by individuals that they had been somehow harassed by Proposition 8 opponents, in your view, do you think that those reports reached enough viewers to have swung the election in favor of Proposition 8?
Again, I find that notion implausible.
Now, the Heritage Foundation report, and in fact, Mr. Thompson's examination and the materials he submitted to you did not contain any examples of violence or harassing activity by Proposition 8 against Proposition 8 opponents. Is that correct?
That's correct.
I would like to just put on the screen demonstrative number 14, which is an expert of Ms. Zia's testimony from earlier in this case. Have you, were you here for Ms. Zia's testimony?
I was not.
Did you review her testimony at all?
I did review the trial transcript.
This is already in the record, so I won't have you read it, but this is evidence in the record that I would like you to explain in terms of its relevance to analyzing this question that Mr. Thompson was putting on the table. Whether the allegation on the one side and the allegations on the one side and looking at those alone could somehow have any bearing whatsoever on the question of political power of gay men and lesbians.
Once again, we would want to look at the sum total of acts of violence, intimidation and poor behavior in both directions. I just, even for people who are deeply committed to their beliefs in one direction or another, just sort of taken aback. It takes your breath away to imagine someone walking up to another human being and saying, you know, out loud on a public street, "You're going to die and burn in hell. Have a nice day." I mean, what's the right follow-up to that? I mean, I can't imagine saying such a thing.
Well, that's what Ms. Zia testified. Among other things, people said to her when she was out electioneering against Proposition 8, correct?
That's correct.
I would like to turn to demonstrative number 13, which is an excerpt from Mayor Sanders' testimony. As you'll recall, Mayor Sanders is the mayor of San Diego, where a number of the incidents that Mr. Thompson pointed to allegedly occurred. Were you here for Mayor Sanders' testimony?
I was.
Since this is in the record, there is no need for you to read it, but if you could generally summarize your understanding of his testimony and explain how that factors into any sort of professionally appropriate evaluation of this violence factor that Mr. Thompson has raised.
Well, obviously, this is evidence of another set of examples of vandalism working in the opposite direction from those that Mr. Thompson identified. And again, from a social scientific perspective, if you wanted to discern what the net effect of these was, you would want to look at the volume in one direction and the volume in the other. And the level of public's awareness about it and the willingness of the public to change their minds on the basis of it. And only then could you conclude that it had any effect on the distribution of votes.
Now, I would like you to return us to Plaintiff's Exhibit 834 at page 9, which I can, to save you the effort of pulling out another binder, I will have it displayed on the screen. As a reminder, that exhibit is the LA Hate Crime Reports.
Okay.
And you testified earlier about that, and the fact that the hate crime reports talked about Proposition 8. If one were to try to evaluate in a fair, professionally appropriate manner, as a political scientist or scholar, would these hate crime statistics relating to harassment of Proposition 8 opponents be something that one would have to consider? If we go to page 9, please. While we're doing that, you may answer the question if you recall the statistics. Actually, I think I went to the wrong page.
I think it's the next page.
It may be the next page.
No, two more maybe.
Well, while we look for that, I'm sure my team can find it. If you could give me your views as to whether would it be necessary to consider actual hate crime statistics relating to Proposition 8 itself in an official government report when we're trying to do a fair, professional study of the topic?
You would definitely want to look at hate crimes reports that are specifically related to the proposition as this report has attempted to do so. I think you would also want to look at hate crimes that took place simultaneously with the contestation of the ballot measure, even if it wasn't specifically related to the proposition. And the reason I mention this is the literature in political science and social psychology suggests that there is a fairly close correlation between hate crimes on the one hand and salience of the community that's being targeted on the other. For example, the Southern Poverty Law Centers documented during the immigration debates in 2005, 2006, early 2007, that hate crimes against Latinos went up considerably, just simply because Latino visibility went up. So I think there is some evidence to suggest that hate crimes against gays and lesbians went up during the persecution of Prop 8, even if Prop 8 was not mentioned during the assault or during the vandalism or whatnot.
And we have now found the section that talked about the number of hate crimes, which included 4 violent crimes and other acts of violence that an official government report specifically tied to Proposition 8. Now, Chief Judge Walker asked you a question about the effect of violence on the efforts of those in the civil rights movement fighting for the rights of African Americans. There were several riots and acts of violence during the civil rights movement in the 60s, correct?
They were, yes. There were, yes.
Could you just describe a couple of examples of the types of violent events where things crossed over into violence? Not something we are endorsing, but just a couple of examples from that era.
Well, they range from a simple, fisticuffs that might emerge in protest, counter-protest, to some number of people in highly confrontational situation not obeying the nonviolence plan and fighting back. For example, we know that there was some resistance offered by freedom riders when they were attacked in Birmingham, Alabama. So they were getting off the bus and they were attacked by an angry mob, and actually the FBI was present but observed it from afar and didn't intervene. Some of the bus riders apparently did fight back, though. The historical accounts of that are a little bit in dispute. That's kind of more the modest end. At the more extreme end, we can think historically of urban riots in Watts and in Detroit and other major cities.
In the Watts riots, I think something like 34 people died. Does that sound about right?
I'm sorry, my historical recollection is just not that precise, sorry. But if you represent that to me, I have no reason to doubt that.
Assume that 34 people died. And let me ask you this. Was that a significant event of violence that many Americans saw on television and read about in the newspapers?
I think that's fair to say, yes.
Notwithstanding that the public saw that, African Americans were able to, at some point, through the courts and other means, achieve advancements in fighting for their civil rights.
Sure. So the 1968 Fair Housing Act was passed after most of the urban riots took place. And I think it would be fair to say that the American public, while certainly not excited to see rioting, would sort of juxtapose that rioting against the extraordinary poverty faced by African Americans, harassment by the police, denied the right to vote in many southern states, etc., that we don't take single incidents and draw broad-based conclusions about the relative social and political worth of an entire class of people.
In your expert opinion, as a political scientist, is there any basis whatsoever for concluding that the handful of incidents that have been brought to your attention by Mr. Thompson have contributed in a material way to the lack of political power of gay men and lesbians in the United States or California?
I think that would strain credulity. I can't see any basis to make that claim.
Thank you. Now, Mr. Thompson also asked you a number of questions about articles, and he showed you the Bill O'Reilly tape and some other materials that post-dated Proposition 8. Do you recall that?
I do.
And in that regard, Your Honor, I would like to publish and play a video. It's Plaintiff's Exhibit 350, which is the Gathering Storm video that counsel on the other side objected to on the first day of trial because it does post-date Proposition 8. But I think the door has been opened to show what those on the other side of the marriage debate were doing after Proposition 8 and disseminating publicly in order to undermine the political power of gay men and lesbians.
Your Honor, that video doesn't in any way relate to the political power of gays and lesbians. So we would object that this is an effort to try to smuggle this evidence in, even though it's been previously rejected.
What does the video show?
It's an advertisement that was put out by supporters of Proposition 8 who were part of the broader campaign, which was meant to talk about the gathering storm and the threat to the public of marriage between individuals of the same gender. And it's at least as relevant to this case as the Bill O'Reilly clip and the other materials that counsel played, because it shows, to the extent counsel was arguing, that these arguments and things that were happening after Proposition 8 somehow could be attributed and deemed factors relating to political power. There's a war going on the other side that is meant to thwart the rights of gay men and lesbians as to marriage specifically, and this video, I think, is a prime example of that.
And just so the record is clear, Your Honor, this was paid for and sponsored by the National Organization for Marriage, not ProtectMarriage.com.
Well, I've certainly taken a welcoming attitude with respect to evidence in this case, and I do think that the subject matter was raised in Mr. Thompson's cross-examination. So if this is in response to Bill O'Reilly's video, I think it's only appropriate and out of fairness to allow the video to be shown.
Thank you, Your Honor. If we could play the video, please. Your Honor, I move admission of Plaintiff's Exhibit 350.
I did admit the O'Reilly tape, did I not?
It's in.
How is this numbered?
This is Plaintiff's Exhibit 350.
360?
350.
350. 350 will be admitted.
Thank you, Your Honor. Professor Segura, you have seen the Gathering Storm video before today?
I had.
And does that, the advertisement, to your knowledge, did it get wide distribution in the United States?
I read a lot about it, and I saw it talked about, so I assume a lot of people have seen it. I don't even recall exactly the circumstances under which I first saw it, but it becomes, it's become semi-famous.
Is there, in your view, the messages that were put out in that video, do they relate to the balance of power on behalf of gays and lesbians on the one hand and those who oppose marriage amongst the people in the groups on the other hand?
It's hard not to look at that video and not conclude that the message of the video is that gays and lesbians are deeply threatening to individuals in American society. The ominous music, the dark storm, one actor saying, "I'm afraid," suggests that homosexuals are to be feared. There is reference to children, references to children. There's references to taking your religious liberty away. There's references to church being discriminated against or facing some form of government repression. It really does present gays and lesbians as a very serious threat to all sorts of aspects of American life.
And is that, that sort of public message something that, in your opinion, undermines the political power of gay men and lesbians?
I think it reinstantiates long-held prejudices about gays and lesbians. It suggests that gay and lesbian social progress comes at the expense of other individuals in American society and other long-held organizations. And it makes the hill steeper. It makes the sledding rougher in terms of trying to enact legal protections or to ward off legal sanctions.
And Mr. Thompson also asked you some questions about news articles and analysis of things as they stood in 1993. Do you recall that?
I do.
Can you tell us, in your view, what has happened since 1993 that, in your opinion, is relevant to evaluating the powerlessness of gay men and lesbians?
It was interesting reading those quotes that Mr. Thompson asked me to look at because my recollection is that in 1990, 91, and particularly after the election of 1992, I think a lot of casual observers thought that there were going to be a lot of really rapid period of progress for gays and lesbians. And some of those statements seem to convey that. They are on the verge of really breaking through, etc. I'm taken aback because, of course, at the time that these statements were made, this predates the enactment of Don't Ask, Don't Tell. It predates the enactment of Defense of Marriage Act. It predates the enactment of prohibitions against same-sex couples or gay individuals from adopting in some of the states. And of course, at the time, there wasn't a single state constitution that had been amended to establish gays and lesbians as excluded from a civil institution. So in many respects, I think this is sort of illustrates how a lot of optimism was dashed by the events that have occurred in the last 16 or 17 years.
I'm drawing a blank, but do you recall when Amendment 2 in Colorado was enacted that was the subject of Romer versus Evans in the Supreme Court? Was that after 1993?
I think it was enacted either in 92 or in 94, the 94 election, but I'm sorry, I mean, I don't recall the exact, recall exactly.
So to your mind, the notion, well, what is your view of the assertion that in 1993, the rights of gay men and lesbians were on the ascendancy and being protected?
I think they are mistaken claims. I think that those are optimistic articulations by advocates who truly believe that the future was bright. I think it's harder to look at the historical record and to look at the statutory record and then and conclude that that was justified. I think that your reference to Colorado's Amendment 2 and the subsequent decision by the Supreme Court is interesting because it lays bare a piece of information that's kind of missing here. Which is the Colorado's Amendment 2. As I was asked about earlier, preempted local legislators and the state legislators from reenacting protection from gays and lesbians and added that to the state constitution, and it was struck down by the United States Supreme Court. So what we really can't observe is whether there would have been other ballot initiatives consistent with Colorado's Amendment 2 that did not occur because gays and lesbians received the small part of judicial protection in Justice Kennedy's decision in Romer. So in fact, the circumstances were as difficult as the circumstances have been for gay and lesbian political interest over the last 20 years in the absence of Romer versus Evans. One would imagine that they would have been even worse.
Well, at some point since 2000, have issues swirling around the civil rights of gay men and lesbians been used as what is known as a wedge issue in terms of political debate in elections in the United States?
So the question is a good one because it sort of illustrates the problem that gay and lesbian advocates face. So the short answer to your question is yes, that there is at least one political party in the United States who thinks that an awful lot of politicians, I should say, who think that there is an electoral gain to be made from targeting gays and lesbians for disadvantage. So it's clear that in many parts of the country, in many sub-electorates, in all parts of the country, there is gain to be made from saying that you don't like gays and lesbians or you are adverse to their interests. In addition, it also sort of illustrates that the non-monotonicity, sorry, that's a fancy academic term, that progress for any social group doesn't necessarily have to be in a straight line. That there's fits and starts and forward and backward. You'll recall in 2003 the Supreme Court in Lawrence struck down state sodomy statutes, making it for the first time effectively legal to be gay in many parts of the United States. And the very next year, in 2004, 14 states adopted anti-same-sex marriage ballots initiatives. So, a lot of folks credit that with altering the turnout dynamics in the 2004 presidential election and helping President Bush to be reelected. So it's very clear to me, anyway, and I think to a lot of electoral studies scholars, that the wedge issue of gay and lesbian identity and the issues that they care about is likely to continue to be a fairly potent force in American politics for the foreseeable future.
And back to Mr. Thompson's questions about violence against Proposition 8 supporters. Have there been instances where rights are recognized of gay men and lesbians that has had an effect on the level of violence directed at them?
Well, as I said, there's some evidence in the literature to suggest that favorable decisions or even the raising of this salience of the particular group is likely to attract more hostility.
Your Honor, may I approach the witness? I would like to hand him an exhibit.
Very well.
I'm handing the exhibit, Plaintiff's Exhibit 398. Here's one for the court.
No objection, Your Honor.
Professor Segura, have you seen this? Do you see what this document, can you tell me what it is?
It seems to be a recounting of the strategic approach used by Schubert Flint in the Prop 8 campaign that was published in Politics magazine.
Are you familiar with Politics magazine?
I'm familiar with the name. I'm not a subscriber.
Are you familiar with Frank Schubert and Jeff Flint, the names?
I am.
Who are they?
They are paid political consultants, as I understand.
And to your knowledge, did they have anything to do with the Proposition 8 campaign?
I believe they were retained in the management or the implementation of the campaign.
Your Honor, I move admission of Plaintiff's Exhibit 398.
No objection, Your Honor.
398 is admitted.
Now, Professor Segura, I would like you to just briefly pursue this, but, well, actually, before I do that, let's turn to the, well, if we could display that, let's publish Plaintiff's Exhibit 398, and I would like to go to the last page. While we're doing that, which is page 5 of this document. And if you could enlarge it, the very last paragraph. And Professor Segura, perhaps you could read it into the record, beginning in, well, actually, not the last, it's the paragraph that begins, members of the Mormon faith.
Members of the Mormon faith played an important part of the Yes on 8 coalition, but were only part of our winning coalition. We had the support of virtually the entire faith community in California. Prop 8 didn't win because of the Mormons. It won because we created superior advertising that defined the issue on our terms, because we built a diverse coalition. And most importantly, because we activated that coalition at the grassroots level in a way that never had been done before.
Well, I will represent to you, Professor Segura, excuse me, that in this article by Mr. Schubert, there is no mention, no suggestion that the handful of alleged acts of violence against Proposition 8 supporters that Mr. Thompson has alluded to affected the outcome of the election. Does that surprise you?
No.
Now, yesterday, you gave testimony concerning the broad-based coalition that supported Proposition 8. Do you recall that?
I do.
And you talked about some of the religious organizations, including the Catholic Church and the Mormon Church, and Focus on the Family, and other groups that had banded together.
I do recall.
I would like you to assume that after we were done yesterday, Mr. Puno, one of the lawyers for the other side, suggested that the line of testimony was somehow the product of animosity and bigotry towards religion. And I would like for you to, whether you two agree with that.
Objection, Your Honor. This seems totally beyond the scope of Cross. I didn't ask him about this subject at all.
You explored at some length the position of these various religious organizations. Objection overruled.
I'm sorry. So the idea is that.
Let me rephrase the question.
Okay.
When you testified about the nature of the coalition that supported Proposition 8, you weren't suggesting that there was anything bad about the religious groups involved for participating in the political process, were you?
Oh, no. So you know, there is an old saying that, you know, if you believe in democracy, you believe in the willingness to defend the other guy's right to be wrong. So whether it's the coalition in favor of Prop 8 or the coalition in opposition of Prop 8, people and groups are freely not just allowed, but encouraged to participate in the political process.
And yesterday you said that the coalition and some of the documents that you discussed suggested an inviolable political operation. Do you recall that?
I do.
What did you mean by that?
As we walked through the documents, a couple of things became clear. So the first is just the extraordinary number of coordinating volunteers, many of whom were pastors, for example, who participated in the conference call, or state presidents who were instructed to identify volunteers in every zip code. The claim that 20,000 members of the Latter-day Saints Church walked precincts 2 Saturdays in a row, or something to that effect. I think that political consultants around the country would love to have that level of grassroots buy-in and activism.
As a political scientist, is it your view that it is let me start over. In the field of political science, is it customary for political scientists to analyze the degree of participation of religious groups in political activity?
It's become a growing area of research. There are a variety of experts who have become quite prominent in the discipline through focusing on regional and politics.
I would like to pull back up Plaintiff's Exhibit 398 on the screen and go to page 2 of 5. Have you turned to that? If you have it in front of you, and go this down, let's see, 1, 2, 3, down to the paragraph, the 6th paragraph that begins, our ability. Have you reviewed that? And if you could read that into the record, that would be much appreciated.
Pardon me. Our ability to organize a massive volunteer effort through religious denominations gave us a huge advantage, and we set ambitious goals. To conduct a statewide voter ID canvass of every voter, to distribute 1.25 million yard signs and an equal number of bumper stickers, to have our volunteers recontact every undecided soft yes and soft no voter, and to have 100,000 volunteers, 5 per voting district, working on election day to make sure every identified yes on 8 voter would vote. All of these goals and more were achieved.
And is that consistent with the documents that you reviewed yesterday in court and spoke about, talking about the broad-based coalition?
In my experience, it's breathtaking.
Now, let's go to the next paragraph that begins, we built a campaign. If you would review that and read the first sentence into the record.
We built a campaign volunteer structure around both time-honored campaign grassroots tactics of organizing in churches with a ground-up structure of church captains, precinct captains, zip code supervisors, and area directors.
Now, Mr. Thompson asked you questions about the unions, their support, financial support of Proposition 8. Based on your study of Proposition 8 and the political activities of the unions in the Proposition 8 campaign, are you aware of any similar mobilization of troops on the ground, boots on the ground, like is discussed here by Mr. Schubert on behalf of those who are opposing Proposition 8 during the campaign?
I'm aware of some activities by Unite here and the SEIU, but nothing on this, even remotely on this magnitude.
How about corporations like PG&E and I think Levi Strauss? Is there any public reports, any scholarly work that suggests that those companies were able to mobilize their employees to go out and campaign and work on behalf of defeating Proposition 8 in a manner that compares with the sorts of efforts we have seen in Mr. Schubert's article and the documents that you talked about yesterday?
I'm not aware of any corporations mobilizing its own employees. I would also wonder about the legality of such a thing, given that workers have some basic right to political privacy with respect to their employer.
Well, now, Mr. Thompson also asked you to look at the funding, the official funding numbers for and against Proposition 8. Do you recall that?
I do.
Why is it that those funding comparisons on each side that he discussed with you, both in the sort of 40 million range, to your mind, do not suggest that there was political parity between the sides in that election?
So campaigns have really two components to them. One is the paid component and the other is the volunteer or free component. And that level of money saying offset a tremendous amount of financial disadvantages, as any grassroots politician could attest. So when I look at the rough parity of the financial expenditures of the two campaigns, those financial reports on both sides, frankly, don't include the volunteer hour time. People who are on the payroll of the other organizations who were devoting all or part of their time to the campaign, the rental of space, for example, for meetings that were provided by coordinating organizations, etc. And the evidence suggests to me that the vast volume of volunteerism, space volunteering, that people on the payroll of other organizations, etc., that a huge amount of that favored the yes on 8. There was a lot of people working for someone else or a lot of space controlled by someone else that was used to organize the campaign, and none of that is accounted for in the financial disclosures. So there you have it.
Well, in your opinion, is that illustrative of the picture in a broader way in terms of the forces arrayed against the gay and lesbian community in the political sphere?
Well, it certainly is indicative of the breadth of their coalition. It's indicative of the resources, the manpower, and the net or the asset resources that they can bring without necessarily even turning to the financial resources. These are, in effect, in-kind contributions, but we don't govern them that way. But you know, the Roman Catholic Church or evangelical churches or whatever, if you're using their meeting space, if you're using their phones, if the pastors are, they are perfectly entitled to do that. That's part of the American process. But it does not suggest that there is a great deal of resources against which gays and lesbians have to work in order to achieve their political goals.
Well, Mr. Thompson also asked you a number of questions about churches and religious organizations that oppose Proposition 8. Do you recall that?
I do.
Now, you were here, or you were, in the overflow room yesterday when the videotape of the proponents' withdrawn expert, Dr. Nathanson, was played. Is that correct?
I was.
Now, do you recall Dr. Nathanson's testimony in response to this question? I'll just read the whole exchange with the court's permission. This was on page 95 of his 96 of his deposition. The question was, now it is true that the religions that supported Proposition 8 that sought to ban gay marriage were much larger than the religions that supported gay marriage. And Professor Nathanson, answer, yes. Do you agree with him?
On that point, yes, I agree with Dr. Nathanson.
And then on page 99, and this was played and entered into evidence yesterday, Professor Nathanson asked, question, and the religions that supported Proposition 8 and opposed gay marriage contributed many more volunteers to the campaign effort than the religions that supported gay marriage and opposed Proposition 8, correct? And Professor Nathanson answered, answer, yes. Do you agree with him on that?
I do. I have no reason to believe otherwise, and the disparity in the demographics would suggest that it couldn't possibly be otherwise.
Now, in your work on this case, you submitted a rebuttal expert reporter to Professor Nathanson's report, correct?
I did.
And that was, well, if you could turn to tab 72A in one of Mr. Thompson's binders.
Oh, I'm sorry.
It should be the rebuttal report.
I'm there.
If you could provide us with a brief overview. Well, and in fact, if we turn to, well, this is marked as, well, let's see, it's on page 2. You provide an overview of the points that you are addressing. Could you give us an overview of what you opined in response to Professor Nathanson's opinions in this case?
Okay. So I organized my rebuttal report pretty much as Professor Nathanson organized his original report for organizational purposes to make it clear. And he offers 4 of what claims that he calls findings. And I summarized them up front, and I will give each finding and tell you what I thought about it and what I wrote about it. So the first claim was that organized religion was not monolithic in its support for Proposition 8 as evidenced by opposing positions across sectarian lines. And my response to him was that while an extreme definition, meaning unanimity, that is true, religious persons were not unanimous in their support for Proposition 8, that the evidence he presented was actually sort of holiness, leading, and silly. So he lists 4 religious organizations in favor and 4 religious organizations opposed without considering the size. And we've just covered his response to the question when he asked in deposition. The 4 organizations he considered in favor, I report in my rebuttal said compromise about 34% of the national population. And the 4 religious denominations he identifies as opposed total 2% of the national population. In the data source I was using, one of the sects he was identifying was Metropolitan Community Church, which is an identified gay and lesbian religious denomination. And that denomination is so small as to actually escape measurement in the report. So it's comparing apples and oranges, and I thought that the claim was misleading.
Well, before you go on to your other 2 points, to briefly summarize, were the organizations that Professor Nathanson talked about and that you were discussing in this report basically the same group of organizations Mr. Thompson was asking you about today? Like the churches that he mentioned today in his questioning of you?
Well, we talked about a lot of religious organizations today, but for clarification, it was the Catholic, the LDS, the Baptist, and the Orthodox Judaism on the one hand, the Unitarian Universalists, the United Church of Christ, Reform Judaism, and MCC on the other. Those were the sects he spoke specifically about.
On the other hand would be the groups that were opposing.
That's correct.
Supporting the opponents of Proposition 8. And just briefly, what were your other principal points in response to Dr. Nathanson's opinions?
So the second claim he offers is that individual sects themselves were divided. And the evidence he uses for this is the existence of dissenter groups within Proposition 8 denominations. And so he identifies a dissenter group of Catholics and a dissenter group of Mormons and a dissenter group of evangelicals, for example. The problem I had with this claim was that he makes no attempt to ascertain the size of these groups, and there is pretty good evidence to suggest that they were very small and that they have very little influence within their churches. So, for example, Dignity, which is an organization of gay Catholics, was identified as a dissenter group, but of course, Dignity has actually faced exclusion from the church. They are not allowed frequently to meet on church property in some dioceses, etc. So again, it was misleading to suggest that there was a very large dissenting organization and that the church was deeply divided over the issue.
Well, if you could just briefly summarize your last 2 points in response to those claims relating to religion.
Okay, so the third was that gay and lesbian organizations do not view organized religion as the enemy. And this was very much akin to the piece of information that Mr. Thompson asked me to review regarding the National Gay and Lesbian Task Force, where it showed that the NGLFTF was trying to engage religious leaders. And Professor Nathanson's claim was that clearly then religion is not the enemy because the gay advocacy organizations are talking to them. And that just struck me as bizarre in the extreme. As I responded when Mr. Thompson asked me, the NGLTF is engaging them precisely because they see religious organizations as the principal obstacle to their political advancement. And I dealt with that in a little bit more detail. And then the final point was that was really the oddest one to deal with, which was Professor Nathanson's claim that support for Prop 8 by religious persons could not be fairly attributed to anti-gay animus. That was a interesting aspect of his report because it defines anti-gay animus in a very, very narrow way, which is he says that we would have evidence of anti-gay animus if religious people acted in bad faith. And that's just an unusually narrow notion of animus without consideration of prejudice or long-held stereotype that is almost nonsensical to respond to. But I made an effort.
And in the interest of completeness, let me just read what Professor Nathanson said in his deposition that was played yesterday in response to a couple of questions. On page 99, actually 102, he was asked, question, let me ask you a question about hostility to gay people, and I will refer to it as gay bashing. Do you believe that the teaching of certain religions that homosexual relations are a sin and abomination contributes to gay bashing? And he answered, yes. Then on page 102, starting at line 24, he was asked the following question. Question, is it your opinion that primary cause of culturally propagated hostility is religious teaching? And he answered, that might be a complex answer. Let me start by saying that in a direct sense, yes. But I think that religious hostility to homosexual behavior in turn has its roots other than religion. Do you recall that testimony?
I do.
And in your rebuttal report, the opinions you stated in that report and that you stated today is that, do you still hold those views? Is that your opinion today?
I still hold the views I submitted in the rebuttal report, that by any reasonable standard, when we look at the array of views held by religious and non-religious people, and specifically the association of religiosity with the views on gay and lesbian issues, as we went through in the tables with His Honor, The most plausible explanation for that is that religious views are related to the actions of religious people.
Now, Mr. Thompson also asked you a question about the Lax and Phillips article that is at tab 71. And, Your Honor, I just have a couple of more questions and I will be done. Tab 71, the Defendant's Exhibit 1105. Do you recall that?
I do.
Is this an article that you are familiar with?
It is.
And if you will look at on page 383, which is the page that Mr. Thompson quoted. It's on the left column, right above, it's the paragraph that, right above the paragraph that begins, "Why might this be so?" Towards the bottom. The last sentence that begins, "It may not be surprising." Do you see that?
I do.
Could you read that into the record, and then I will just ask you a question or two.
It may be surprising that minority rights suffer when the majority is opposed to them, but our results show that representative institutions do a poor job protecting minority rights even when the public supports the pro-minority position.
Is that statement by Lax and Phillips consistent with your views concerning political power of gay men and lesbians?
It is, with the footnote that on a number of key issues for gays and lesbians, they do not enjoy majority support, but yes, it's consistent.
And let me ask you two more questions. In light of the legislative measures that provide some protection to gay men and lesbians in California and some of the prominent politicians that Mr. Thompson pointed you to, who have been allies in one way or another of gay men and lesbians, do you believe that gay men and lesbians still lack political power as you have defined it?
I do. The series of questions Mr. Thompson asked me about the statutory enactments in California and the number of politicians in California who have been supportive of the gay community, I think serve as the basis of his skepticism regarding the conclusion that I draw. I would want to respond to those in a couple of ways. The first is that I have repeatedly in my testimony suggested that we need to look across levels of government. We need to look across jurisdictions in order to evaluate the political power of the group. Protections afforded that end at the county line in a modern society are hardly protections at all, and that would be the same. The same would be true at the state line. That we need to look not just at the federal level or not just at the locality. We need to look at all levels of government. But more importantly, we look at a series of statutory enactments. Some of them pursuant to court decisions, some of them overturned by ballot initiatives in several states. And when that skepticism is expressed, I do a mind experiment that I do with my students frequently, which is I explore the counterfactual. So I imagined for a moment that I was going to write an opinion that says gays and lesbians are powerful in the political system. So I go and I survey the world and I survey the literature and I say, well, the FBI suggests that gays and lesbians are experiencing increasing levels of violence and represent 70% or more of the hate-inspired murders. Could I see that and still conclude that the group is powerful? Well, conceivably, because there are other factors. Could I look at the circumstances around the country and say, well, in 29 states, gays and lesbians could still be dismissed without cause for their identity from their source of employment, that they could enjoy no protections? Could I observe that and still conclude that the group was powerful? Well, possibly. Could I observe that even small statutory protections designed to redress previous disadvantages have been challenged at the ballot box over 150 times, and gays and lesbians lose those more than 70% of the time, and still conclude that the group is powerful? Presumably. Could I look at the enactment of constitutional exclusion and establishment as excluded from a civil institution as a citizen that is separate, that is treated separately from all other citizens, and conclude that the group is powerful? I could conceivably observe one or maybe two of those things and still decide that there's other evidence to suggest that the group is powerful. To observe all of those things and to conclude that gays and lesbians have the political power to protect their basic rights in the political system would be the political science equivalent of malpractice. I couldn't possibly draw that conclusion.
And no further questions, Your Honor.
Very well. Mr. Segura, thank you for your testimony. You may step down. This would be a good time to take our lunch and recess. Can we resume at 1:10? And your next witness is going to be?
Mr. Tam, Your Honor.
Mr. Tam. Very well. I look forward to seeing you at 1:10. Very well, Mr. Boyes, please call your next witness.
Thank you, Your Honor. We call Dr. Hockshing William Tam.
Your Honor, Terry Thompson, representing William Tam. I have one preliminary issue, if you wouldn't mind, that we talk about before we begin the examination, before he's sworn in. On the 8th of January, I filed on behalf of Dr. Tam a motion for withdrawal in his interventor status, and opposition papers and reply papers were received on the 13th. That was about a week ago. And I haven't seen any order yet on that. And I think it would be appropriate to know before he begins his testimony whether his voluntary withdrawal as a party interventor has been granted, or he's here because of a subpoena. What his status is, whether he's a third party or whether he's a party intervener.
Mr. Boyes?
Well, Your Honor, as we indicated in our papers, we think it's too late for him to withdraw. He brought this case. He's now going to testify in this case.
Well, he didn't bring the case, but he voluntarily
Intervened.
joined the case.
He joined the case. He intervened. He intervened in the case. And we think that you can't intervene, litigate it, and then decide in the middle you want to get out of it. So as we indicated in our papers, we don't think it's appropriate for him to withdraw at this time.
Ordinarily, under these circumstances, Mr. Thompson, a defendant seeking to withdraw after having either brought a case or, in this case, intervened in a case, would accept a judgment. Now, some of the difficulty that I've had with this situation that you present, it's hard for me to envision what kind of judgment Mr. Tam could possibly accept that would be a reasonable basis for permitting him to withdraw at this juncture. Do you have anything that you'd like to add for further consideration in this regard?
Well, I think the basic issue is his intervention was purely voluntary. Even if the case is it's to benefit to intervene, you don't have to intervene. And by the same token, withdrawal is purely voluntary. And even if plaintiffs have stated in some of their papers that if he didn't like the intrusive nature of the discovery, he could withdraw. And they mentioned that several times. And so he's mentioned some compelling reasons for withdrawing, which are in his declaration in my motion. But frankly, I don't believe that he needs any. I couldn't find any compelling or controlling legal authority that said that he needed anything to withdraw other than his interest in withdrawing.
Well, there have to be some consequences to a party joining a lawsuit, then putting the other side to the expense, the effort of litigating against that party, and then withdrawing. Typically in this situation, it would be, as I've said, the acceptance of a judgment or some other relief that would redress what has been done to resist the party that had intervened. And it's hard to imagine under these circumstances exactly what that could be. In addition, there are some testimonial reasons why proceeding as a party may be somewhat different than proceeding as a third-party witness. And because of the uncertainty as to how those factors might play out, I thought that this is something that I need to address perhaps after Mr. Tam testifies. And he is going to testify one way or another, either as a party or a non-party.
Yeah, that's right. He's here, and he's been here several days.
Yeah, I've noticed that, and you've been very good about attending. So that rather leads me to think that the more prudent course of action would be to hear Mr. Tam's testimony, see what that amounts to, and then consider what his status should be going forward. So my inclination would be to continue to defer the matter until such time as his role in this case has been completely clarified.
Well, just as far as his deposition, if he were a third party, then his deposition could be used to impeach, but it wouldn't be allowed to be
Yes,
entered.
as a party. As you, I am sure, know, a person's deposition can be used by the adverse party at any time in the course of the trial for any purpose.
Right.
And so that makes some difference. I don't know what prejudice there could possibly be to the plaintiffs in the event of a withdrawal. Perhaps after Mr. Tam's testimony, the plaintiffs may consent to the withdrawal, or perhaps not. So I kind of thought that the better course of action would be just to see what his role is in the underlying facts and what his role in the litigation is, and then to evaluate what, if any, action to take on the motion to withdraw. All right?
All right.
Thank you, Mr. Thompson.
Call Dr. Tam to the witness stand.
Raise your right hand, please. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please take a seat. State your name, please.
Hak Singh William Tam.
How do I spell your last name?
Tam
And your first name?
Haksing.
Thank you.
Good afternoon, Dr. Tam. We haven't met yet, but my name is David Boyce, and I represent the plaintiffs. Now, you were an official proponent of Proposition 8, correct?
Yes.
And the way you got to be an official proponent of Proposition 8 is you were invited by ProtectMarriage.com to be an official proponent, correct?
Yes.
And in connection with the campaign for Proposition 8, you worked with a number of people from ProtectMarriage.com, correct?
Yes.
And those people included Mr. Prentice, correct?
Yes.
And Mr. Puño?
Yes.
And Mr. Schubert, correct?
Yes.
Now, were there any others from ProtectMarriage.com that you recall that you worked with on the campaign?
Probably some clerical person that emailed me about like a conference call or something like that.
Okay.
Or somebody called me about going to a press meeting or something.
Okay, thank you. Now, in October of 2008, you supervised the preparation of the language for Proposition 8, correct?
And I don't quite understand what does supervise mean.
Well, sir, let me ask you to look at tab 1 of the binder that's in front of you.
You mean PX0507?
Yes, sir.
Okay.
And this is your declaration, correct?
Yes.
That you declared under penalty of perjury was true and correct, correct?
Yes.
And if you turn in this declaration to paragraph 6.
All right.
All right, do you see what you write there? In October 2008, I supervised the preparation of the appropriate language for Proposition 8.
Well, I don't quite remember what that particular document is. if you can remind me.
But what particular document are you talking about, sir?
The appropriate language of a Proposition 8. But I did, if it is about the 14 words on Proposition 8, that I did agree to it. And yeah, if this is sense supervision, that if it is not the 14 words, I wouldn't go along with it. And then I agree that's supervision.
Well, the declaration that you have in front of you,
Yeah.
that you have signed,
Yes.
did you prepare this declaration?
No, I did not.
But who prepared the declaration?
From Protect a Marriage.
ProtectMarriage.com
Yeah, protectamarriage.com.
prepared this declaration for you?
Correct.
Well, let me just understand what you're saying. ProtectMarriage.com prepared this declaration that is Plaintiff's Exhibit 507 for you, and you signed it.
Yes, I signed it.
So the language here that says in October of 2008, you supervised the preparation of the appropriate language for Proposition 8, that was written by ProtectMarriage.com. Is that correct?
Yes.
Well, did you invest substantial time and effort and personal resources in campaigning for Proposition 8?
Yes.
All right. And between January of 2008 and November of 2008, did you dedicate the majority of your working hours towards qualifying Proposition 8 for the ballot and campaigning for its enactment?
Yes.
And you organized several rallies in support of Proposition 8, correct?
I helped, yes.
And in doing so, you worked with people from ProtectMarriage.com, correct?
No, the rallies were not originated by protectmarriage.com.
Now, you say originated. My question to you was whether or not in connection with the rallies you worked with the people from ProtectMarriage.com or not.
No, because those rallies were mainly Asian Americans, and those are the people that I knew, and I only invited the protectmarriage.com's Ron Prentice to be present and to be one of the speakers.
You invited Mr. Prentice to be one of your speakers at the rally, correct?
Yes.
And Mr. Prentice was the chief executive officer of ProtectMarriage.com, correct?
Right.
Right. And do you consider that working with ProtectMarriage.com in connection with the rally?
Yes, I would say so.
Okay, I would too. Now, in connection with Proposition 8, did you personally take part in the debates?
Yes, I did.
And for example, you had a debate on Channel 26 here in San Francisco, correct?
I had a debate here in San Francisco, not at Channel 26. Channel 26 came and made a report that night. So debate was not originated by Channel 26.
But it was a debate that was covered by Channel 26. Is that what you're saying?
Right, right.
Now, this debate that was covered by Channel 26, it was a debate in which you were campaigning for Proposition 8, correct?
Yes,
And you were told by the people at ProtectMarriage.com to participate in that debate, correct?
yes,
Now, this is the campaign for what became Proposition 8. Now, this campaign began in 2007, correct?
could you specify at 2007 if the collection of the preparation of the collection of signatures is considered as a campaign? Then yes.
Well, and for example, in October of 2006,
2006?
no, I'm sorry, 2007.
2007. Right.
Yes, in October of 2007, you were waiting for instructions from ProtectMarriage.com of when you would start collecting those signatures, correct?
Yes.
And eventually, ProtectMarriage.com gave you instructions as to when you should start collecting those signatures, correct?
Yes.
Your Honor, I object to the leading nature of most of these questions.
Well, Mr. Tam is an adverse witness. He is a party on the other side of the case. Objection overruled.
In January of 2008, you sent an email to pastors and church leaders on the instructions of ProtectMarriage.com, correct?
I don't know what you are referring to.
Well, that's a fair point. Over the course of January and February and subsequent months, you sent a number of emails to pastors and church leaders on the instructions of ProtectMarriage.com, correct?
What do you mean by on the instruction of Protect Marriage?
Well, in cooperation following discussions with ProtectMarriage.com. Well, you would talk to them, you would agree what needed to be done, and then you would do it, correct?
They sent out emails, right, to ask the church leaders to collect signatures. Yeah, after discussion with ProtectMarriage.com.
Okay.
That
Objection, Your Honor.
that can be started, yeah?
These letters to the pastors and church leaders were all attorney's eyes only. So I would respectfully request that if any of these are trying to be introduced, that they are not introduced in court. Also, while I'm up, if I could ask for a standing objection similar to what you granted the proponents regarding First Amendment privilege, as questions get to Mr. Tam's personal political views, motivation, and that sort of thing, that I'd like to have in order to preserve standing objections on First Amendment privilege grounds similar to what you granted the proponents. And I know that this was lost in the appeals court, but I'd like to preserve that standing objection.
Fair enough. You can certainly preserve that as a standing objection, and therefore you don't have to make an objection to every question that may implicate the issues.